There is now various methods of resolving disputes short of going to trial. Sometimes these methods are used after a lawsuit's filed. Sometimes they're used before the lawsuit's filed. Collectively, the methods are called alternative dispute resolution. Lawyers like to use a shorthand of ADR. There are primarily two alternative dispute resolutions methods that are fairly common. They are mediation and arbitration. What a mediation is an independent person is selected, usually by agreement of everybody involved. Often that person is a retired judge or an experienced lawyer. And everyone gathers with that person, who then seeks to facilitate the parties getting together and resolving their disputes, or at least part of their disputes. Basically, a mediator brings the sides together. That's quite a bit different than an arbitration. In an arbitration, everybody selects an arbitrator, again, often a retired judge, sometimes an experienced lawyer, and the case is submitted to that arbitrator in a pretty much informal process usually. Often, instead of having live witnesses, there's written documentation. And that arbitrator makes a decision just as a judge would, judge or a jury, and that decision is then binding on everyone. We call that sometimes a binding arbitration. Sometimes arbitrations also have connected to them what's called a high-low agreement. So let me give you a simple example. Let's say we have an automobile accident and the plaintiff believes the claim is worth $100,000. And the insurance company for the defendant believes the claim is worth $20,000. They might make a binding high-low agreement in the range of, say, $10,000 to $110,000. They make an agreement not to tell the arbitrator what those high-low amounts are. The case is then submitted to the arbitrator. The arbitrator decides a value. If the value decided by the arbitrator is between $10,000 and $110,000 in my example, that is the amount that the insurance company pays on the claim. If the amount is below $10,000, the plaintiff is guaranteed they get no less, and the insurance company would then pay the minimum of $10,000. On the other hand, if the arbitrator decides an amount above $110,000, the insurance company is guaranteed they don't have to pay any more, so that the amount the insurance company would pay in my example would be a maximum of $110,000. Since it's fairly common that an insurance company is involved, or that whoever might have to pay a judgment wants some kind of limitation to avoid a jury giving a crazy off-the-wall verdict, binding high-low arbitrations are getting, and have been, actually not getting, they've been popular for a time. I've been using them in my practice for over 20 years. So if you have a civil lawsuit going on, it's usually worthwhile getting an experienced mediator involved and at least trying a mediation, and if you can reach a binding arbitration agreement, doing a binding arbitration. The money that is saved in legal fees by handling disputes, by alternative dispute resolution, can be very significant. It can amount to a saving of tens of thousands of dollars in legal fees. So if you have a lawyer who's talking with you about mediation or arbitration, it's wise to pay attention and seriously consider it.